business landscape all over the world can either be usual or unusual, depending on who you ask.
In Nigeria, the 2020 amendment to the Companies and Allied Matters Act, otherwise known as CAMA, has added to the level of how usual or unusual the business landscape will be in the country.
So, how will CAMA affect the operations of small businesses,
large corporations,
conglomerates,
voluntary organizations,
non-profit and non-governmental organizations? Banwo Ighodalo, a Tier 1 law firm in Nigeria, is committed to helping you understand the CAMA 2020 and the implications for your businesses. Listen and get the facts of the Act. Welcome to the new innovation in CAMA 2020, brought to you by Banwo Ighodalo. In today's podcast, we'll be looking at company incorporation and incidental matters under the revised Companies and Allied Matters Act. Toyin Bashir, a partner at Banwo Ighodalo, will discuss incorporation and compliance requirements under CAMA 2020 with respect to companies and lots more. So, CAMA 2020 has simplified the requirements for incorporating a company in Nigeria. Can you tell us more about the new innovations relating to, first of all, minimum number of members?
The new innovation in relation to minimum number of members relates to the provisions of Section 18 of the Companies and Allied Matters Act of 2020, which, for the purpose of this discussion, I will refer to as CAMA 2020. Unlike the Companies and Allied Matters Act 1990, which for the purpose of this discussion, I would refer to as the repealed law, where a minimum of at least 2 members were required to form private and public companies, Section 18 of CAMA 2020 now provides that a private company may be formed by one person, provided the company is a private company as defined by Section 22, subsection 1 of CAMA 2020, which is to the effect that the Memorandum of Association of the company clearly states that it is a private company. To this end, the minimum number of members to form a private company has now been reduced to 1, while the minimum number of members to form a public company still remains 2.
What about the issue of authorized share capital?
So the new innovation in relation to authorized share capital is contained in Section 27 of CAMA 2020. Under the provisions of CAMA 2020, the notion of authorized share capital was replaced with the notion of issued share capital. This is by virtue of Section 27, subsection 2 of CAMA 2020, which specifically provides that if the company has a share capital, the Memorandum of Association shall also state the amount of the minimum issued share capital, which shall not be less than 100,000 in the case of a private company and 2 million in the case of a public company. This implies that a company is required to issue all of its shares to the subscribers or promoters of the company. Companies are now only permitted to create shares which they require at the point of registration and also subsequently when there is a need to allot new shares to either existing shareholders or new investors. And as such, companies can no longer have unissued shares. Having said this, unfortunately, CAMA 2020 does not provide a timeline for companies to update the relevant corporate documents, that is the Memorandum and Articles of Association, to reflect issued share capital. Neither does CAMA 2020 provide for a timeline for companies to issue all of its shares, nor state what will happen in the event that a company retains unissued shares which have already been created That is whether or not the shares will be cancelled by operation of law. Notwithstanding, we expect that the regulations to be issued by the Honourable Minister of Industry, Trade and Investment through the Commission will speak to these identified gaps.
So what about the innovations relating to minimum subscription by subscribers to the Memorandum of Association?
The new innovation in relation to minimum subscription by subscribers to the Memorandum of Association is contained in Section 27 of CAMA 2020. Further to my response to the previous question, the minimum authorized share capital has been replaced under CAMA 2020 with a requirement for companies to maintain a minimum issued share capital. However, in addition to the minimum authorized share capital being replaced, CAMA 2020 also increased the minimum subscription for companies. Under the repealed CAMA, a private company was required to have a share capital of not less than 10,000 naira, whilst a public company was required to have a minimum share capital of 500,000 naira. These minimum financial thresholds have now been reviewed upward in CAMA 2020 to a minimum issued share capital of 100,000 naira in the case of a private company and 2 million in the case of a public company. All of these shares are expected to be subscribed by subscribers to the Memorandum of Association at the point of registration. Further, Section 124.3 of CAMA 2020 provides that where at the commencement of the provisions of CAMA 2020, the issued share capital of an existing company is less than the minimum issued share capital introduced by CAMA 2020, the company shall not later than 6 months after the commencement of CAMA 2020 issue shares to an amount not less than the minimum issued share capital. So for instance, if an existing private company currently has a share capital of 10,000 naira, in order to comply with this provision of CAMA 2020, such company is expected to increase its share capital, and in this case, its issued share capital up to the value of 90,000 naira within a period of 6 months from the commencement of CAMA 2020. In the event that a company fails to comply with Section 124, subsection 3 of CAMA 2020, the company will be liable to such fine as the Commission may prescribe by its regulations.
How about re-registration of companies?
The new innovation in relation to re-registration of companies are contained in Section 75 and 71 of CAMA 2020. The key addition to the provisions on the re-registration of companies is the introduction of the option of re-registration of a public company as an unlimited company under Section 75 of CAMA 2020. However, certain conditions have to be fulfilled, amongst which are that all the members of the company must have assented to it being re-registered as an unlimited company. The public company has not previously been re-registered as a limited or unlimited company, and an application for re-registration is delivered to the Registrar General of the Corporate Affairs Commission in accordance with Section 76 of CAMA 2020, which is that the application must contain a statement of the company's proposed name on re-registration, and same should be accompanied by the prescribed form of assent to the company's being re-registered as an unlimited company, authenticated by or on behalf of all the members of the company. It should also be accompanied with a copy of the company's memorandum and articles as proposed to be amended, and a statement by a director of the company that the requirements as to re-registration as an unlimited private company has been complied with. In particular, the statement of compliance is to contain provisions that the persons by whom or on whose behalf the form of assent is authenticated constitutes the whole membership of the company. And if any of the members has not authenticated that form himself, the directors have taken all reasonable steps to satisfy themselves that each person who authenticated it on behalf of a member was lawfully empowered to do so. The second one relates to Section 71 of CAMA 2020, which provides that an unlimited company may be registered as a private limited company if a special resolution that it should be re-registered as passed and application for re-registration is delivered to the Commission together with the prescribed documents listed in Section 72 of CAMA 2020, as well as a statement of compliance.
So can you also tell us about the innovations that relate to procedures for application by a foreign company for exemption from incorporation in country?
The relevant provisions which relate to applications by a foreign company for exemption from incorporation in country is as provided under Section 80 of CAMA 2020. Under the repealed law, a qualified foreign company that intends to carry on business in Nigeria without being incorporated as a company in Nigeria was required to apply to the President of Nigeria through the National Council of Ministers for exemption from the requirement to incorporate a separate entity in Nigeria. This was provided for under Section 56 of the repealed law. However, under Section 80 of CAMA 2020, a foreign company is now required to file an application for exemption directly to the Minister of Industry, Trade and Investment, setting out the following: the name and place of business or the proposed name and place of business of the foreign company in Nigeria, the name and address of each director, partner, or other principal officer of the foreign company, a certified copy of the charter, statutes, or memorandum and articles of association of the company, or other instruments constituting or defining the constitution of the company, and if the instrument is not written in the English language, a certified translation thereof. The names and addresses of one or more persons resident in Nigeria authorized to accept on behalf of the foreign company service of processes and any notice required to be served on the company. The business or proposed business in Nigeria of the foreign company and the duration of such business. Particulars of any project previously carried out by the company as an exempted foreign company, and such other particulars as may be required by the Minister of Industry, Trade and Investment. Once the foreign company is granted such exemption from registration, such foreign company is required to deliver to the Corporate Affairs Commission, upon payment of a prescribed fee, a notice of its exemption within 30 days of the grant. If an exempted foreign company fails to comply with this provision, it will be liable to such penalty as the Corporate Affairs Commission may specify in its regulations for every day during which the default continues. Also, where an exempted foreign company fails to deliver to the Commission in every calendar year a report in the form prescribed by the Corporate Affairs Commission, such exempted company will be liable to such penalty as the Corporate Affairs Commission shall specify in its regulations for every year of default.
That was Banwo and Ighodalo's Toyin Bashir explaining incorporation and compliance requirements under CAMA 2020. In our next episode, we'll take a look at shareholder board meetings and company secretarial matters. business landscape all over the world can either be usual or unusual, depending on who you ask.
In Nigeria, the 2020 amendment to the Companies and Allied Matters Act, otherwise known as CAMA, has added to the level of how usual or unusual the business landscape will be in the country.
So, how will CAMA affect the operations of small businesses,
large corporations,
conglomerates,
voluntary organizations,
non-profit and non-governmental organizations? Banwo Ighodalo, a Tier 1 law firm in Nigeria, is committed to helping you understand the CAMA 2020 and the implications for your businesses. Listen and get the facts of the Act.